If you want to come forward, please, and give us your name and address.
Yes, Charles Parsons. Address is 34541 Daisy Road, Frankfort, Delaware, 19945 3246. We own the land that's just directly west of Sycamore Chase expansion. And naturally, the fact that we don't own that land is that we have no control of what takes place there. We just don't want to be infringed upon because of what they're doing there. I have a question on the compliance with the 50-foot lands in agricultural use. Now, some people may think that the land that we own is not in agricultural use, but I am currently using it in regenerative agricultural use, which is very popular in Europe. So instead of a 20-foot buffer, which is shown on the proposed plans, I would like to know why that's 20 and not 50. Anybody care to?
Mr. Whitehouse?
I can assist with this, Mr. President. Let me put the plan back up on the screen. So the code calls, and let me just do a plan that shows a buffer. The code calls for a buffer. This is the forested buffer around the perimeter. If adjoining lands are in agricultural use in terms of 50 feet, there is a requirement that the new lots have the agricultural protection notice. That's the 50 feet, that anyone living within 50 feet of agriculture effectively put on notice that they're living next to agricultural lands. The buffer is different, though. The buffer is doesn't, where you have adjoining agricultural lands, it doesn't increase the buffer to 50 automatically. The two mechanisms that operate in parallel is what I'm trying to say, Mr. President.
I'm sorry, I don't really understand that. I read where it said 50 feet from agricultural lands, not from houses that were built or on agricultural lands.
So where you have a lot that is located within 50 feet of lands within active agricultural use, there is a requirement, and this can be controlled through a condition and implemented through the Commission, that there be an agricultural protection notice placed, and staff would regulate that as part of the final site plan review process. The question here is whether the buffer should be increased because of the lots being within 50 feet of lands within active agricultural use.
So the notice that you're referring to is the typical agricultural notice that goes in deeds that state that the people purchasing understand that this is in an agricultural neighborhood. There may be noise, dust, odors, those kind of things, so that they're aware, so they do not complain about the neighboring use. Is that what you're referring to?
That's correct, and that can be required by way of condition. We check for it anyway, but that can be specifically made by way of condition.
What I'm referring to is document 53797, page 5, where it says 50 feet from agricultural lands. It's a written document on your website. That's indicating 20 right there. Is that correct?
Here, sir. So this is page 5 of 53797.
Well, the document I was reading at the top, it said document 53797, page 5, yeah. Or, wait a minute. I'm sorry, 54683, I'm sorry. Number 4, page 2. be right about there. Up,
So the number one more time. Page 4, is it?
well, there's a reference there on buffers and agricultural land. I thought I wrote down 54683, number 4, page 2. But
Yeah, it might be a different reference. It may be a reference to a different document, Mr. President, but in terms of the buffering requirement, that is certainly open to council's control. Should council decide to require a different buffer, that can be required by way of conditions.
well, I think this is probably laid out by the Department of Agriculture, is it not? Is that laid out by the Department of Agriculture?
So where you have an improvement or a dwelling located within 50 feet of active agriculture, we are required in our code to make sure that that active agricultural protection notice is inserted into the restricted covenants for the property. So we have a role in creating that, so yes.
I understand you insert it, but when is it going to be shown on the site plan?
It can certainly be a requirement of the site plan.
Well, I think there's
condition
two
H.
different things here. I think this gentleman is asking about a 50-foot physical buffer. What the code calls for is if somebody's going to build a house within 50 feet of an ag land that's active, they must be notified in advance that that's ag land before they buy the house. That's not saying you're talking about an actual buffer. The code
correct.
says 50 feet. If your land were today, and I want to buy a lot next to your land, and I'm within 50 feet of that, they got to tell me that you've got active agricultural land there before I buy my house. I don't buy it and then say, oh, there's something wrong. They got chicken manure on the field or whatever, you know.
You're not just building a house.
Houses, they all have to be notified.
Multiple.
Yeah, everybody have to be notified. But what you're saying is if the council were to choose, they could certainly insert 50 for 20 as a buffer, right? Okay.
And in condition H, it says a 30-foot wide vegetative buffer shall be established along the entire perimeter.
Okay, so
What planning and zoning's
planning and zoning recommends a 30-foot buffer.
Yes.
Okay.
It's only shown at 20, is that correct?
Yeah, well, if planning and zoning recommends a 30-foot buffer, we
I
can,
mean on the site plan.
What's the site plan show?
So it showed 20 as part of the original submittal, but
Okay.
the commission's committee. So the applicant would have to amend their site plan if they obtained approval to match the requirements of the conditions.
Because planning and zoning recommended 30 feet.
yes.
Okay.
And if this council recommends the same thing, when it goes to the final site plan, it will be amended, the plot, to show that 30-foot. I do have one question, sir. Is your land in an agricultural preservation district or easement? Have you placed it in agricultural preservation
I have
land?
not,
Okay.
but that land has been in tillage at least 124 years that I know of.
Right,
So it would qualify for the Century Farm.
right.
I just have not made those steps.
Yeah, the reason I asked about the preservation district, there are different setbacks. In those cases are mandated by the state in the easement. But if it's not, then that's
You're
different.
asking me something I don't really know.
You would have had to have actually placed it into an easement, gone up and had a district created, and then afterwards, through an appraisal process, possibly sell an easement on the property.
Oh,
That's
yeah.
that's a much different
Yes, no, I
process.
have not done that.
Okay. Okay, thank you.
The other thing I would like to bring to your attention is that in the plot plan, I think it's, you look at William Canal, prong 8. It would be plan, let's see. I guess it would be The one there that's, yes, I think that's the one. There's a, the tax ditch requires an 80-foot right-of-way, top of bank. I think you're not sure you're, no, you're down at Daisy Road. You need to go up. Okay, next to our wooded land, prong 8. Okay, it's, if you take your cursor and go a little to the right and up. Yeah, right there. Okay, now show the plot plan with the houses on those property lines. Should be at C.
May be a technical question for the applicant's engineer. What is the future of that? Because
if you can get to the plot C, okay, C, right there, and enlarge it. I have to go to another page. Yeah, click on that one. I think that's it. Okay, right there, prong 8. You'll see that's prong 8 over to the left side of the screen. And there's the right-of-way, that the tax ditch right-of-way is 80 feet. Now, it looks like to me that some of those property lines are not quite at the 80-foot mark.
Is the 80 feet in total width of 40 foot from each side, or is it 80
Top
each
of
side?
bank. Top of bank.
Yes.
Top of bank is 80 or 40 and 40?
No, top of bank 80 feet.
Yeah.
Both sides?
No, it's a wood on the other side.
Yeah.
Okay.
Yeah.
I can explain this person. So right now, what we're talking about is this distance from top of bank here is 80 feet on this side. And on the applicant's plans...
Proposed 40.
It's now proposed to be 40. So the applicant appears to be proposing a modification to the tax ditch easement as part of the subdivision.
Yeah, because I called Denver.
It's 80 feet for a purpose.
Yeah,
It is possible with the state's agreement, but that is part of the proposal that is before us.
it's that reason, because when they clean out the tax ditches and whatever's, the clean out has to be spread out. That's why it's that purpose. I called DENREC, and there was a court order change, number 1, to make that 80 feet in 1953. And I know that in some instances, some of the subdivisions have encroached on that, even putting buildings within the right-of-way. So all I'm asking is that what we living or owning the property adjacent, that we are not infringed upon. It doesn't bother me that there's a subdivision there. It just want to make sure that it's done the way it should be done. That's all. Nothing more, nothing less. So that's all I'm asking. And there's what's being done here in Sussex County. It's really changing. It's changing the whole character of the community. I mean, there's at least 10 existing communities very, very close by. Some of them are very large estuary. And there's even more waiting for approval. So that's all I'm asking. My sister here would like to say something.
Hi, good afternoon. Thank you for letting me speak. My name is Sherry Parsons Merritt. I currently reside in Girdle Tree, Maryland, but I grew up adjacent to the property, the Sycamore Chase. I graduated in 1978, and I spent my whole life there except recently. The farm has been in the family for 124 years, which would be 6 generations. My problem, I guess, is the access point to Sycamore Chase. There is a farm easement where the access would be coming into, and that would cut off our property, our land that is beside this development here. That was an agricultural right-of-way that's been there forever. And we would have no access. That would landlock that piece of property that we have. If this were to go through as to where they're wanting to put their access road into the development. Like I said, I have no problems with the development, but please do it on their property. Please leave ours alone. I'm currently soon to be retired. I plan to move back, and I currently had a horse business before I moved away. I'm going to start that back up again. We also have the property that isn't going to be in that, and I'm not going to use, is currently, Murray Brothers is under contract to till that property this spring coming. But like I said, my problem is that access road is going to landlock our property. We would have no access to it, so basically it would be no good to us.
Warehouse, can you bring that up and show this access
Yes.
we're talking about?
Move my mouse cursor. Is it access here where my mouse cursor is here? Sure, go ahead.
Where the access is, they want a easement on our property that would take what's existing there. They want to take this part of this here and make it and that's road frontage that they're taking away from us. Also is taking away our access back to our property that we already have back there. And we have no other way to get back there.
So I have a question then. You're saying that is your land and you're giving them an easement, or it's their land that you have an easement across?
They would like us to give them an easement. They wanted us to sign an easement stating that we would give them, a DELDOT thing, maybe 2,000 feet of our property, but that's where our road is to access our property in the back.
So that was probably a deceleration lane or something of that sort?
Likely, yes.
And
yes.
so through that width is where your entrance is into your property?
Right. And like I said, I have no problem with them doing their development. That doesn't bother me. If they want to do that, that's fine. That's their property. They can do with what they want. But please don't infringe on us and take our only access back there. Maybe we're not going to do agricultural, whatever, but that cuts that land completely off to us. We have, it devalues it. And like I said, we want to keep this property in our family. I mean, 124 years and 6 generations
Mr. President,
is a lot.
We certainly can't make you give them an easement.
Right,
Nor
right.
would we try to.
But they
That's
want it,
entirely,
and if,
what they can want all they want.
Right.
Unless you sign the piece of paper, they'll never have an easement.
right,
That's just fact.
Right.
Right.
That's
That's
just fact.
correct.
but that's what they're wanting us to sign a
That's-
piece of
and that
paper saying they want that
decision is yours
easement.
and your brother's, I guess, or whoever owns that.
Yes.
Yeah.
Yes.
But yeah, but there's nothing this body will ever do to make you or try to make you
Right.
give somebody an easement to your
Thank
land.
you.
Yeah.
Thank you.
If you don't want to do that, that's entirely, you can keep that land another 124 years.
Yes, yes. And like I said, they can do what they want with theirs, that's fine. Please don't infringe on us. Please do not.
That's not going to happen.
That's all I'm asking, is please don't infringe on us. You know, they've got like 75 acres there. I don't see why they couldn't move things over.
Sure.
But thank you so much for
Thank
letting
you.
me.
Yes, ma'am.
Thank you. Is there anyone else that would like to speak in opposition? Anyone else? Seeing none. Operator, is there anyone listening remotely that would like to comment?
At this time, there is no one on the line.
Thank you, Operator. Mr. President, at this time, we can close the public hearing on this matter, and if council desires, close public record.
We'll close public hearing. It's okay with council, close public record. And Mr. Moore, with a short title.
Thank you, Mr. President. An ordinance to amend the comprehensive zoning map of Sussex County from an AR1 agricultural residential district to an MR RPC medium density residential planned community district for certain parcels of land lying and being in Baltimore 100, Sussex County, containing 73.95 acres more or less for the reasons given by planning and zoning numbered 1 through 9 with conditions 10A through R.
Pleasure, council.
Mr. President, I think at this point in time, there's certainly a need to defer for further consideration.
Motion, Mr. Hudson, second. Mr. Riley to defer all changes in 1991. Questions on the motion? We'll take the vote. Mr. Hudson?
Yes.
Mr. Schaefer?
Yes.
Mrs. Green?
Yes.
Mr. Riley?
Yes.
I vote yes, motion carried. Changes in 1991 was deferred. Mr. Moore next.